State in this honorable court.
Good afternoon. Our next case is Hinman versus Cornett, and we will hear from the appellant.
Mr. Chief Justice, Associate Justice, may it please the court, I'm Tommy Doughton from Forsyth County. I represent the plaintiffs, the Hinmans, and the appellates in this matter, William and Joanne Hinman. I'll reserve 5 minutes for rebuttal. This court today has the opportunity to reaffirm a long-established principle in North Carolina, that a party must come forward with sworn testimony of each and every element of their claim to survive a motion for summary judgment. I want to go over just briefly, because I've reviewed these surveys many times in this case, and I just want to go over and explain to the court in detail exactly what strip of land and what we're dealing with. And I've got a copy of what's in the record on page 8. This is a survey that was done by Mr. Riccio. It's throughout the record in multiple times. It's attached to my client's affidavits as well. But I want to just point out that to the Cornett's property, just to the west of their property line, is a 30-foot easement. No question about that. It's been there for some time. It is an easement to access their back lot, or lot 2, we sometimes refer to it. That easement, though, that 30-foot easement, runs into a portion of the Hinman's paved driveway that they use to access the back through their property, which is really to the south of the Cornett's property. That 30-foot easement probably goes roughly, I'm going to say roughly, to the middle of the Hinman's driveway. Some portions of the driveway, it's about 3 feet on the driveway. Some portions of it, it's about 6 feet. So that's the easement, that's the area that we're talking about, and it does go partially onto the Hinman's driveway. That's the property we're dealing with. Now, my position is that the defendants in this case failed to offer evidence of each and every element of adverse possession. To acquire title to land by adverse possession, the claimant must show actual, open, hostile, exclusive, and continuous possession of the land claimed by the prescribed period under known and visible lines and boundaries, and that's from the Jones versus Miles case, which I've cited in my brief. They must present evidence of each and every one of those elements, and that's what I believe they failed to do. Now, the only place you need to look for evidence from the defendants on this matter, they didn't file an affidavit in this case. The only place in this record where there's any sworn testimony from the defendants is their depositions. I took their depositions, I handed up their depositions to the trial court on the motion for summary judgment. That's the only sworn testimony. That's the only thing that you need to read to determine whether there's evidence in those depositions of each and every one of those elements. Now, there are some, I believe, undisputed facts that I want to point out to the court. The Cornetts regularly used that driveway to drive to the side of their property and park in their carports, and it was with permission from Mr. Church, who's a predecessor in title to the property, and the Court of Appeals points out it was with permission. It's in their deposition that it was permission. So using that driveway was with permission, and it's not hostile, not adverse, and I don't think there's any issue, at least currently, with respect to claiming adverse possession to any portion of the driveway.
Isn't the only issue, am I misreading the Court of Appeals opinion, but isn't the only question about adverse possession between the pavement on the 30-foot strip and their property line? Isn't that the only question that's really before us?
That is the major portion, but the dissent also pointed out that the claimants did not prove each and every element of their adverse possession. But there's no question that the dissent's focus was on, there was no hostile evidence of the use of the land between the driveway and their western boundary. And that land is pretty much just grass and mulch and a little bit of a drainage ditch and so forth, so it's not paved. That is the main issue. I want to point out a couple of presumptions that apply in this case. One, use of property in North Carolina is presumed to be permissive. That's the presumption. Also, the law does not favor adverse possession. You cannot show adverse possession when the true owner is never put on actual or constructive notice of the possessor's hostile intent. That's a critical point in this case because I don't believe there's any evidence of that. The true owner must.
Did they plant trees or put other structures, anything in the area that the adverse possession claim survives, which is between the pavement and the property line?
Yes. And two of those items, it was admitted in the Cornett's deposition, particularly the concrete pipes, were done with Mr. Church's knowledge, and Mr. Church had no problem with them in putting those pipes in. Also, the crepe myrtle trees that were planted, the Cornetts testified that Mr. Church knew about those trees and had no problem with those trees being planted. And that's pointed out in the dissent's opinion as well, which those facts are ignored in the majority's opinion when they find that there's an issue of fact regarding adverse possession. Now, another important issue in this case, not necessarily dispositive, but I think it's important, is with respect to adverse possession, they've got to show where this land is that they're claiming adverse possession over by known and visible lines and boundaries. Here's what they alleged in their counterclaim. And their counterclaim is not verified, but here's what they alleged. All encroachments have been between the western side of the 30-foot easement and the easternmost side of the paved road for the length of the defendant's tracks 1 and 2. Now, the western side of the 30-foot easement is in the middle of our driveway. The eastern side of our driveway is the eastern side of our driveway. That's the only thing they alleged as to where the encroachments were. They didn't allege in their counterclaim that they were claiming adverse possession to this strip of land that's the dirt between the driveway and their western boundary. It was not alleged. But here's what the Court of Appeals did in the majority opinion. They said the Cornetts clarified at summary judgment hearing that they alleged adverse possession only to the strip of land of their garden, brick pillars, and several trees. Where did that language come from? It's not in their deposition. It's not sworn to. It's what their trial lawyer argued in opposition to my motion for summary judgment. A trial lawyer's, or any lawyer's, argument is not sworn testimony or facts that can be used to defeat a motion for summary judgment. It also can't be used to establish your known bounds and lines that you're claiming adverse possession over. It's got to be pled. It's got to be proved. That didn't happen. Now, I also want to point out one other case where this court in 2013 in Minor v. Minor said you must plead and prove every element of adverse possession. If you go to their counterclaim, they didn't plead any of the elements of adverse possession. You will not find them, and the counterclaim is in the record on page 14 to 16. You will not find the words open, continuous, exclusive, actual, or hostile anywhere in that counterclaim.
They don't have to use the actual words if they're putting forward facts that meet that standard.
Well, Minor v. Minor case says you must plead and prove every element. To me, when the court says you got to plead it, I take that to mean you got to state it.
Well, they have to come forward with facts that meet those standards.
I don't believe that's what the Minor case says. I believe Minor says you've got to plead it in each and every element of it. That's what the Minor case says. They didn't do it. And I did use the conclusory allegation that we've claimed land by adverse possession. There's no question those words are in there, but they didn't plead each and every element of it. The main elements that are missing here with respect to adverse possession are hostility.
I wanted to follow up on that just so I understand.
Sure.
So your position is what that case stands for is not only would you have to allege the facts that would establish adverse possession, but then in alleging that the legal relief you're seeking is the adverse possession, you would have to spell out the legal standard saying each of the criteria that's required to show adverse possession, and if you didn't use the magic words there, the claim fails. Is that what you're saying?
Yeah, I'm not sure that I'm saying you have to allege every fact, but you have to allege the actual words.
Right, okay, the facts I added, because I thought that was, you have to have the facts, and then you have to say these facts are adverse possession, but you're saying,
No,
No,
that you acquired this land, that it was open, that it was continuous for more than 20 years, we had exclusive use of it, we had actual use of it, and it was hostile. I think that meets that criteria. I don't think you have to say how hostility occurred in your pleadings, but ultimately you have to come forward with evidence of it. But I do think.
I was flipping it around, what if you have facts that would meet all those criteria, and you say this is adverse possession? You're saying if you didn't use each of the magic words in the test, of all of the criteria you have to meet, the claim fails?
That's what I believe the minor case says, Your Honor. That's my interpretation of the case. When the court tells you got to plead something, I think you have to plead it, and that's the way I read it. But I will say this: no one's agreed with me on that point yet, or even addressed it. It's been routinely ignored. But that's my reading of the case, and I believe that's what the case says from 2013. The primary issues with respect to adverse possession that are missing here are hostility and exclusive. Those issues are not addressed anywhere in their deposition, and they're just completely lacking because, one, if we establish permissive use, we win on hostility. And the deposition shows that Mr. Church was aware that they were putting these concrete pipes in, and he was fine with it. He was aware that they were planting the crepe myrtles, and he was fine with it. That defeats hostility. And there's no evidence offered that they put a fence up to keep people out of it or put a sign up that said no trespassing. That would be exclusivity. None of that. There's nothing in the record regarding that. I also want to point out a couple things the Court of Appeals said where they're just clearly applying the wrong standard. This is on page 582 of their opinion or reported opinion. And the court writes, nothing in the record suggests the Cornetts received permission from the churches or their successor entitled, the Hinmans, to possess and erect permanent structures on the disputed strip of land. First off, that's the wrong standard. We don't have to prove permissive use to win this case. They have to prove hostility to win this case. So that's the wrong standard. Furthermore, it's just not correct because, as I've mentioned several times, the churches did approve of the concrete pipes going in and the crepe myrtle trees being planted.
So I want to make sure we're on the same page about what our precedents say about what this element of hostility actually requires, because in Potts v. Burnett from 1981, we cite Dickinson versus Pate, and for a lot of language about hostile doesn't mean that you have to show there was a heated controversy, any manifestation of ill will, or that the claimant was in any sense an enemy of the owner of the servient estate. There's just evidence accompanying the user which tends to repel the inference that is permissive and with the owner's consent. And it seems to me that this also runs up against our doctrine that you can adversely possess even if you're mistaken. Like if you actually believe you have the right to the land and you're possessing it, you can establish adverse possession, again, even if you're mistaken. So in those circumstances, you know, if you think you own the land, you wouldn't be seeking permission, but we've said you can still establish adverse possession.
There's no question you do not have to show ill will or a fight or a major confrontation between the parties to establish hostility. There's no question about that. There's no question, or at least I don't believe there's a question that you can adversely possess something that you think you already owned. I think that's a fair statement of the law. But what you have to do is you have to exercise control over that land to the exclusion of everyone else. And you also have to tell the rightful owner, this is my land. This is mine. And I'm claiming ownership of this.
But can't you essentially tell that you are claiming ownership over it by the actions that you take with regard to the land, right?
Depending on the actions, that's correct. But those actions don't exist in this case. And that's the example I meant. Like if you put a fence around it and put up no trespassing, that would be a hostile showing that this is my land, I claim it. That doesn't exist. If you put up no parking, there's other cases where it was a parking issue and you put up no parking signs. But yes, there has to be an outward, some type of activity, statement, something that you've done to tell the rightful owner, this is my land. Not just that you just use it. Just using it does not establish adverse possession. And that's what they're doing here. They're saying we used this land for a long, long time. Now it's ours. And that's just not the law in the state of North Carolina. But yes, you can establish adverse possession by certain actions, but there's no evidence that they took any of these actions in this case.
On the exclusivity prong, I mean, the Hinmans weren't parking in the carport, they weren't getting stuff from that garden, right? I mean, there's no dispute that all of the use and benefit of the carport and the garden was to the Cornetts.
With respect to the carports, that's correct, but the Hinmans did, and there's testimony in there, they did mow that strip of land periodically. But I think that the bigger point here is, at least as I understand their argument, the Cornetts contend they had adversely possessed this property before the Hinmans ever bought it. So I don't, just to be honest with the court, the fact that we mowed the grass on that strip, I don't think necessarily defeats their claim for adverse possession, because they're claiming they had already adversely possessed it before we ever bought it. But there was nothing on that. Matter of fact, we built a fence. That's part of the case. We built a fence right along their property line in this easement, and after we were there. And it's still standing there today, and the court, at least the trial court, said the fence was fine, and I'll get to that argument in just a minute. But yes, we used that property. We exercised some control over it while we were there. And here's the other problem with this case, or just adverse possession in general. How do we know what people did 20 and 30 years ago that are no longer here? This is extremely difficult matter to deal with, because most of these people are dead. You can't go back and ask them what they did. So that's, but to answer that question, let me go on to a couple of things the court
Why
said.
doesn't that difficulty that you just mentioned, why doesn't that make it an issue for the jury?
Because they still have to come forward with sworn testimony of each and every element of adverse possession. And when they do not do that, then the issue is not presented to the jury. And they have not done that in this case. But the fact that someone's dead and it's difficult to prove your case doesn't mean that you automatically get to go to the jury. Or the fact that they're dead and we don't have their testimony to defeat their claim doesn't mean that we automatically win. So again, to get to the jury, they've got to come forward with sworn testimony of each and every element of their claim. And I'm confident they did not do that based on the only sworn testimony in this record. The court also points out, in the majority opinion, the Hinman's predecessor entitled The Churches had an opportunity to discover and remedy the Cornett's encroachment for over 20 years, but did not do so. That's totally irrelevant to this case as to what the churches did. In fact, I think it cuts in our favor, because if it was permissive use, the churches don't have any reason or any obligation to do anything. But the majority opinion seems to be assuming something that there's no facts on. And I think it was inappropriate for the court to do that. They also pointed out the churches allowed the Cornetts to use the driveway. It says, well, the record demonstrates the churches allowed the Cornetts to use the driveway, but contains no indication that the Cornetts received permission to possess the disputed strip of land of their land on their own. Again, I've mentioned it several times, but the churches did approve the concrete pipes and the crepe myrtles at a bare minimum. So that statement is just not correct, and the dissent points it out. I want to point out a couple of other issues in the case that I think rise and fall all on the adverse possession case. If you rule in our favor on the adverse possession case and reverse and say trial court was correct in granting summary judgment, I don't think there's any question that we win our trespass claim on summary judgment as well. And Court of Appeals all but says that. There's no question that the carport, chain link fence, the split rail fence, the reinforced concrete pipes, the brick columns, crepe myrtles, driving up and down our driveway are all on our property, but for the adverse possession claim. There's no dispute about that. Our clients signed affidavits to that fact. The surveyor signed affidavits to that fact. There's no dispute regarding that matter. Same thing with the fence issue. If you reverse on the adverse possession claim, the Court of Appeals all but said, but for the adverse possession issue as to actually who owns this land where the fence is valid and enforceable in North Carolina because the Cornetts never raised any objection to claiming that the fence impeded their right to use or access their back lot. So I think those issues go away. They rise and fall with respect to the adverse possession issue. I want to raise one other final point that really is not controlling in my case at all, but it's just something that's bothered me about this case and the law in North Carolina on adverse possession since I got involved in it. I just want to mention it. My clients are innocent third-party purchasers of property for value of which there is nothing on record at the Register of Deeds or the clerk's office to show or put anyone on notice that the Cornetts are claiming adverse possession to this property. Our law firm did the title search. When they bought this property, our lawyers searched the title and found nothing to show that anyone was claiming adverse possession. As I understand the law in North Carolina today, and it's been the way for some time, I don't think someone who claims property by adverse possession is required to put anything on notice, to tell an innocent third party, hey, this strip of land's mine. It's not yours. And I just think that's fundamentally wrong. If you claim adverse possession and you've acquired property by adverse possession, at some point in time, some reasonable amount of time, you ought to have to do something to put on the Register of Deeds or the clerk of court's office to put third parties on notice that this land's now mine.
Isn't that, I understand your point, but isn't that an argument that's better directed at the legislature than this court?
I believe adverse possession was created by the courts a long, long time ago.
Right.
I don't think the legislature has created a adverse possession law, and I may be wrong about that, but I don't believe it has. So to me, when the court creates the law, the court can address an issue that's not fundamentally fair if they want to at a later time. I think the legislature could address it if they wanted to, but it's just like the one I think of all the time is contributory negligence. Contributory negligence, as I understand, is created by the courts a long, long time ago in North Carolina, and if the courts want to change it, they can.
But that doesn't really help you, though, does it? Because as I understand it, what this court has said is, yes, although contributory negligence was created by this court, it's been part of our law for such a long time that if it's going to be altered, it's for the legislature to do that.
Yeah, there's no question the court has said that. I'm just saying if the court wanted to, they could change contributory negligence if they wanted to. But my point is the same thing with adverse. It doesn't have to be addressed in this case. It doesn't have to be addressed. I'm just making a point. It's something that just fundamentally has bothered me since I got involved in this case. It's just hard for me to believe that in 2024, someone can claim that you own a strip of land and nobody's on record to know that. That just, to me, just needs to be addressed at some point in time by somebody.
I just wanted to clarify for myself to make sure I'm understanding the record correctly. In the Riccio surveyor's affidavit, which is page 50 of the record, okay. He says that so I'm trying to trace where the easement is created and what the property is that, who owns the property underlying the easement. And on paragraph 4, it says the 30-foot easement on the west side of the Cornett's property is on property conveyed to the Hinmans in book 3444 pages, and then it has 3342 to 3344. But am I correct that that's a typographical error and that it should say book 3461 and that you're referring to the deed that begins on page 18 of the record.
I'd have to double check that.
I realize
And that could be a typo, but there's no question that, at least from title records in Forsyth County, the Hinmans own the tract of land that this easement's on.
right. But I
But
was-
for the adverse possession claim, that property was conveyed to the Hinmans.
I was just trying to clarify what was on the record in this case.
Yeah, and it is conveyed in the deed where the Hinmans got the original property.
Thank you.
To follow up, you rightfully say that there's nothing on record about this adverse possession. That's certainly the way the law works in North Carolina. But when your clients purchased the property, did they not get a survey at that point and would have had the opportunity to see that there were these encroachments at that time?
They did not get a survey at the time, but they did shortly thereafter. But that doesn't address the issue. They might have shown the encroachments, but it wouldn't have shown that the Cornetts were claiming adverse possession over this property. And they did get a survey shortly after they bought the property, and that's when all this came to light. But it wouldn't have addressed the issue of adverse possession. It would just have shown encroachments.
But they would have at least known that there were encroachments on their property, and then they could have decided whether they wanted to proceed on with the purchase, had they
Correct.
gotten a survey. I just want to
Correct,
make
but-
sure I
but-
have my facts right.
That's correct. But it wouldn't have addressed whether they actually own the property. All right, I'm going to reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Hear from the appellee.
Good afternoon. May it please the court. Mr. Chief Justice, Associate Justices, my name is Richard Monday, and I represent the defendant appellees, the Cornetts. April Wood's decision is completely consistent with established North Carolina law and the record in this case. Her opinion was both thorough and correct in that there are genuine issues of material fact and that granting summary judgment was in favor of the plaintiffs was inappropriate. But before discussing what this case is about, I want to discuss what it's not about. I believe it's important, this is an appeal arising from Judge Tyson's dissent. The statute granting such an appeal, 7A-30, is a narrow grant of jurisdiction to this court, as this court recognizes in its own rules of appellate procedure. As this court has explained many times, any issue that has not been explained or objected to by the dissenting judge is not within this court's ability to review. There are opportunities for my friend to bring those issues, and that is through either petition for a writ for certiorari or discretionary review. That was not done. With that in mind, there's only one issue for this court to decide: whether there are any genuine issues of material fact on hostility. That is the only issue that was raised by the dissenting judge. We agree with the majority opinion in that there is genuine issues of material fact and that this case should be remanded for a trial. But before I address the permissive use issue, I do want to clarify how the parties and the conveyances worked out. So originally, the property owned by the Hinmans was owned by a gentleman by the name of Copeland. He sold that property to the church gentleman, and then they eventually sold that property to the Hinmans in 2019. On this side, the property that was originally Tract 1, the back lot that had the easement, was sold to a woman by the name of Miss Tilly. At the time she purchased that Tract 1, she obtained that easement. And then she later purchases Tract 2. She begins renting that tract with the Tract 1, Tract 2, and the easement to the Cornetts in 1983. At that time, there was already a carport that encroached, there was already a fence, there was a brick column, there was the easement, and then there was a gravel road that was already outside of the easement. So there was nothing at the time in 1983 that would suggest that this area was outside, or this disputed area was outside of what they were renting. And in 1995, when all of that was deeded to the Cornetts, it would not be clear, because there's nothing in the record to suggest that a survey was done at that time, that this road was outside the easement. So it would have been clear to the Cornetts that when they purchased this property, knowing that there's an easement for them to access their driveway, that this land, where there's already stuff encroaching onto, was theirs. And this is a mistake of fact case. They did not come in with the mind of the thief and try to steal this land from the churches. But there's also, and that brings up an important point, where I think the dissent and my friend, they're arguing, they kind of read too much into the depositions. All that was said in the deposition was Mr. Church fine with it? Not, did you ask Mr. Church permission? Because who asked permission to do what they can do on their own land? Now, you might consult with your neighbor, like, hey, do you mind if I do this? Because I might have to come onto your property line. And so the record's not clear here. And with the summary judgment standard, we have to take that in the light most favorable to the non-moving party. In this case, the Cornetts. So these factual issues should have been resolved in their favor, or at least the assumptions that arise from those facts, and that would generate a generation of material fact as to whether or not the churches did give permission, because it's not clear from this record that that's the case. And so the dissent relies primarily on three cases for its decision: the New Covenant Worship Center versus Wright, Jones v. Miles, and Eason versus Spence. None of these three cases actually have any bearing on this case. The New Covenant Center has kind of a convoluted fact pattern, but basically it was a land deeded for a church. Part of it was you have to use it for a church. It sat empty for a long time. There was some weird conveyances that really don't really matter, because what this case stands for is that where you let land sit abandoned and people are actually dumping cars on the property, and this time period goes by, the statute of limitations is not running at that point, because you're not using exclusive use. It's not even a permissive use case. It's exclusivity. Jones v. Miles is also factually, and I'll say this, these cases turn on their facts. It's almost a negligence type situation where each case is very fact specific. And in those cases, summary judgment's also inappropriate. But Jones versus Miles is inappropriate to this case, because in Jones versus Miles, you had two neighbors. One neighbor thought he owned this little strip of land next to his driveway, and eventually found out after 11 years that he didn't own it, that it actually belonged to the neighbor. And he goes and can tell the neighbor, hey, I think I own this land by adverse possession, basically under color of title, which would be 7 years under that 38. But the neighbor tells him, no, it's ours. And so he goes, hey, I think I own this land, but I just want to buy it from you, so that way we don't get into a lawsuit later. Neighbor says, absolutely not. We're not going to sell it to you. But you can keep using it. And that was an explicit grant of permissive use. And the court in that Jones v. Miles was absolutely correct. That's told the statute of limitations, because there was that, even though he kept using it, he was using it with permission. That's not this case. There's nothing in the record that says.
Distinguish that from the Cornetts, your clients admitting that Benny Church said you can use the driveway.
Well, the driveway is not the issue. And that's where I think the
you're saying
dissent
it's
also
a
makes
logical
a
leap.
mistake,
Okay.
is they conflate, hey, you can keep using the driveway, or you can use the driveway. Because I don't think the churches knew that this driveway wasn't in the easement. I think everyone going back, but that's not within our record.
You're saying the fact question is created is, we don't know what that permission was for.
Right.
So if it was undisputed that the permission was, yeah, use my land.
Well, you
that
can
would be
use the
different.
driveway, but it'd be a different question. It's like, hey, you guys can go ahead and put that carport there. We would have a very different case here. I don't think we would be here today. But that's not what happened. With regard to the other stuff, like the crepe myrtle trees and the drainage pipes, There's nothing in the record that actually says, I asked for, that churches gave him permission. In the depositions was, did anyone fuss at you about it? No. What's that mean? That's a factual question for a jury. That can't be resolved on, I'm sorry.
Why isn't it that, I mean, you agree there is a presumption of permissive use?
Correct.
So why wouldn't, if we have to construe that testimony, why wouldn't we construe it to favor permissive use?
Well, because I think it goes to the summary judgment standard. I mean, that still applies. Now, if the evidence in the light most favorable to the non-moving party does not overcome that presumption.
So how do we interpret that, the testimony that, you know, the churches were okay with the drainage pipes? How do we interpret that in the light most favorable to your clients?
That they were simply okay. That wasn't a grant of permission. They just acknowledged, my client acknowledged in his deposition that his neighbor didn't have a problem with him doing it. That's a very different thing to say that the churches came over and said, I saw you were putting a drainage pipe in my cul-de-sac, or in my culvert, or in on my property, and I really appreciate you doing that. You're helping me out.
Doesn't it seem a little bit, though, like you may be shifting the burden from the adverse possessor to establish hostility to the property owner to, you know, deny permission?
And maybe that is maybe this should be a time to revisit that. The majority of cases, I think this is the Potts case that discusses it, where they were urged to abandon the presumption of permissive use and instead adopt the majority rule of permission or presumption of hostile use.
Did you argue that in your brief?
I was not the counsel at the Court of Appeals. I did not raise that in my brief.
So that issue's really not here, right?
I don't, but as counsel has wanted to put forward some ideas, maybe this is an idea for future cases to move this law forward. I don't know if it is properly presented.
But we do have to decide what hostile means.
Right.
And isn't there, in some sense, a logical inconsistency between the notion that you could adversely possess by mistake, and yet there's a presumption of permissive use?
Right.
Because it seems to me that if the two can't coexist.
Right, and I 100% agree with that, and that's why I don't think Potts really kind of fits in. Although the court in that case declined to change the presumption, they did rule in favor and say that they're actually, you did overcome that presumption.
But isn't the
so I don't know if that, but I'm sorry.
Well, I was just going to ask, isn't the case from our court that establishes the notion that you can adversely possess by mistake? You can think you actually own it and adversely possess. Isn't that later than Potts?
I would have to go back and check the dates. I don't know that from memory. But I would agree that there is an inconsistency here. Because this is, throughout the deposition, I think it's undisputed, they believed, honestly, that they owned this land, this disputed tract, which again is about 35 feet wide by maybe 100, 150 feet long. I'm not completely sure on the length, but it's not a large sliver of land. They thought, as they testified repeatedly in both of their depositions, that the easement was the road, because that's what they were told when they purchased it, presumably because that's what Ms. Tilley thought when she purchased it. And so they completely believed this, and they acted consistent with the true owner. They used it, they put it to useful use. And so I don't think they should be punished for that. Now that we are 20 years, they purchased the property in 1995, 20 years would have ran 2015. And now here we are in the 2024 fighting over something that they've consistently been doing for decades. The other case I want to address is that Eason versus Spence, and that is a case that dealt with a life tenant, and it was actually a very interesting case on remainderment rights, but basically what that case holds is that the statute of limitations does not begin tolling when you're under disability, or something similar to akin to disability, because remaindermen do not have an interest in land until the life tenant dies, and so they could not have sued and protected their rights until that life tenant died, then they can come in and sue. So adverse possession would have started as to the remaindermen when the life tenant died. And that time period, and that was less than 7 years before there was a suit. So all that is required to overcome the presumption of permissive use is such a use as to give notice that such use is being made under a claim or right. This has not really been difficult to do. So even if we don't overturn or change the presumption, there are plenty of cases where this case falls in the middle, where we've said there's been permissive use on both sides. The Lancaster versus Maple Street Homeowners Association involved someone who purchased a very large, big tract of land and thought that he had this lot, and then there was a couple extra lots around a lake. At the same time, there was a homeowners association of houses along the lake that mistakenly thought that this was part of their homeowners association land. And so they began using it. They installed wooden posts alongside the lakeside property. They maintained the property by cutting trees and cutting grass. They put up some chairs, stuff consistent with what ownership would be. That is not, and the court said that that was hostile. That was enough to be hostile. That is very close to the facts of this case. If you look at the history of what they were doing over the years as they continued to use this property. But the even more clear case is the McManus versus Klutz case. That is a case where you had two homeowners, both of whom had deeds that overlapped. As a lappage case. Well, the one party basically used theirs as storage space. They let it overgrow. And the adverse possessor, all they did was mow the grass regularly and plant 3 bushes. And that was enough to show hostility. My clients have done far more than that. So I believe that we have overcome that presumption by the actions that they've taken. And which is undisputed that these things have occurred. There's no dispute as to the fact of when these encroachments were put in and what they were. That's shown through the easements and that's shown through the deposition testimony.
Are there portions of the deposition testimony that you think are particularly instructive that you'd like to point us towards?
I would have to go back through I cited in my brief, I believe, where they discuss the encroachments, but but on page 29 of Wade Cornett's deposition, what you see is, and many church never complained about you using the driveway? Oh no. And then he goes on.
Well, by using the driveway, we're talking
Right.
about the area between the paved portion.
It's scattered throughout, Your Honor. The deposition covers a great many topics, most of which are not relevant to this appeal, such as the use of the spite fence or the trespassing issue. And so they kind of, in both depositions, they kind of go through and talk about each of these things kind of one at a time. So for me to sit and point each, I don't know, would be useful.
Well, then summarize it. I mean, tell us what in the deposition you think creates an issue of triable fact.
Sure. So the one, they testify that they both testify they believe they own the disputed tract. That was their land that was deeded to them originally. But they began planting trees in the garden in 1983 in the disputed tract. A carport was erected in 1991. A wood fence was erected in 1992. They purchased the property in 1995. An additional carport was erected in 1996. The chain link fence was erected around the rear carport in 1998. They maintained a garden and planted crepe myrtle trees since before 1999, probably as far back as 1996. And these are the encroachments into the property. They also regularly mowed the property because they believed it was their yard. All of this was done. But to respond to your question earlier, Chief Justice, or Justice Earls, you can prove hostility by actions alone. And to, addressing some of the issues earlier, with regard to notice or the pleadings in the case, we are a notice pleading state. As long as you allege sufficient facts to make out the elements, you've pled a cause of action. And I don't think minor versus minor stands for more than that. If there are any more questions, I would like to close with this. The majority opinion correctly states the principle: at the expiration of the requisite period of possession, the possessor acquires fee simple title to the land. A new title is created, and the title of the record owner is extinguished. By no later than 2015, the title of the disputed tract passed from the churches to the Cornetts. And for that reason, I believe that the opinion of the Court of Appeals should be affirmed, and I yield the remainder of my time.
Thank you, counsel. Rebuttal.
Apologize.
That's fine, you're fine. Time I've got left, I want to address just a couple of issues. Justice Earls, you asked where the deed was in the record. I don't know about Mr. Ricchio's affidavit, but in the record on page 18 is the actual deed to the Hinman's property, and it references being recorded in book 3461, pages 3342 through 3344. That's on page 18 of the record, is the actual deed to the Hinman's property that they bought.
Thank you.
I also want to point out, it's in my brief, but I also want to point out, if you look at the deed to the Cornett's property, in bold print on the first page, it says no title search performed. What that means is, when they bought this property, no lawyer sat down with them and went over what they owned, what this easement meant, and so forth. I think that's why we're here today, but that's in the record as well. They had no title search done. And Justice Allen, I think you're exactly right. They're trying to put the burden on us to show permissive use. That's not the law in North Carolina. They must show that their use was hostile. We don't have to show permissive use. They have to show hostility. But if we do show permissive use, we win the hostility issue. So let me just close by saying, for the reasons that we've stated in our brief, and as I've argued here today, we believe the court should reaffirm the trial court's order, reverse the Court of Appeals on the adverse possession claim, and grant our motion for summary judgment and dismiss the defendant's counterclaims. Thank you.
Thank you, counsel. Mr. Clark.